How should we understand the Fourth Amendment in the face of technological change? It's now possible to communicate with each other in ways we never thought possible. We email, tweet, text, and we even have virtual courses like this one. Some of these technological developments were unthinkable a decade ago, let alone at the time of the founding and the construction of the language of the Fourth Amendment. Should the Fourth Amendment change along with these new technologies, or are its requirements still as good as ever? In this section, we'll look at how the court has responded to some of these changes, particularly wiretapping, bugging, and surveillance. We'll also discuss the court's ultimate protection or deterrent for Fourth Amendment violations, the Exclusionary Rule, which requires that evidence obtained in violation of the Fourth Amendment cannot be used against you at trial. The court's position on wiretapping, bugging, and surveillance was only developed in 1967, some 46 years ago, well after tremendous technological change had already been experienced in the United States. Why did the court take so long? One answer is that the court held to what we call the Trespass Theory, which held that the Fourth Amendment's warrant requirement was only triggered when the police physically searched your property. In one of the first cases to challenge warrantless wiretapping of phones, Olmstead versus United States in 1928, the court held that wiretapping was not a search and thus did not require a warrant, and the evidence seized could be used against Roy Olmstead, one of Seattle's biggest bootleggers. Incidentally, Mr. Olmstead was also a retired Seattle police officer who figured he could make more money in bootlegging than policing. The court's rule was that the Fourth Amendment only applied to material things, and because the police only tapped the wires leading from Olmstead's warehouse and did not trespass onto his property, their actions were legal. It would take the court almost another 40 years, however, to correct their course. In Katz versus the United States in 1967, the court finally held the Trespass Theory wanting, as they ruled that a warrant was necessary for tapping a telephone. In doing so, the court went out of its way to explain that the Fourth Amendment protects people, not just places, in their right to privacy. To aid in determining just when privacy was manifest and the protections of the Fourth Amendment kicked in, the court developed a two-pronged test. First, the individual must exhibit an actual expectation of privacy, and second, that expectation is one that society is prepared to recognize as reasonable. The last case in the section for this week, Kelo versus United States, is a perfect example of changing technology, privacy expectations, and the Fourth Amendment, as the court considered whether the Agema Thermovision 210 thermal imaging device used by police to measure radiating heat in a home was probable cause to raid Danny Kelo's house. When they did, they found a lot of marijuana, but they would not have been able to do this without the device. We'll see how the court sought to resolve that problem in this case. So what should the court do when there's a Fourth Amendment violation? Some countries allow these types of violations and then hold the police officer civilly liable. But here in the United States, courts use the Exclusionary Rule, which bars evidence garnered by police that violates the Fourth Amendment. Should a simple mistake by police bar the evidence that would convict a patently guilty person, for example? Is the Fourth Amendment thus just a legal technicality that lets the guilty go free? Or is it one of the few ways that courts can deter abuses of the Fourth Amendment? The answers are not easy ones, especially because they've become so politically charged in the last few decades. So keep these ideas in mind as you read these cases for this section.